Constitution of India. The life of a written constitution, like the life of the law, is not logic but experience. And after 68 years of experience has shown us it is easier to draft a constitution than to work it. You have to work it. We will never be able to piece together a new constitution, as I said, in the present day and age, even if we try, apart from the number of people who have different opinions. Because in constitution making, there are invisible forces that can never be ignored. One, the spirit of persuasion. Two, the spirit of accommodation. And three, the spirit of tolerance. All three are at a very, very low ebb today. Very low ebb. We have had our problems these 7 decades. Despite judicial and constitutional attempts at containment, there has been linguistic factionalism. It has fostered a spirit of regionalism. So much so that from decade to decade, regional, not national parties, have strengthened their roots, becoming far more vocal, more dominant in Indian politics. Then we have had our difficulties. First, about a national language itself. The speaker spoke to you in Hindi, I speak to you in English. They are both national languages. But it created a big stir at one time. We almost broke up. India would never have been India if you read our history. But for the language resolution which got passed by one vote, it got passed by one vote. And it was not because people wanted English, didn't want it because to anglicize our people. No. It was to keep North and South together. North and South had to be kept together. And that's what continued to make one nation. So now Hindi and English are both accepted as national languages, as I said, to keep North and South together. One of the great things that has happened, which I must tell you about, in these 68 years, particularly after the 1980s, is that, and some of you were here in the morning session, that what I believe to be a creative judiciary, despite the fact that you may say something against judgments or judges, etc., has enlarged the concept of this right to life in Article 21 of our Constitution. You see, the right to life really means, normally, if you read it, all that it means is the right to a person to live. You can't take it away without the authority of law. But judgment after judgment after judgment has said not only the right to life, the right to live well, the right to a healthy life, the right to a proper environment, the right not to be polluted, all these come under the right to life. And why? I always thought that this was an overburden, which was unnecessary, because it doesn't textually fit into our Article 21 if you read it. But Professor Bakshi, who's here, has quite rightly pointed out that you see we have a fundamental right chapter in which Article 21 is there, that is the right to life and liberty. But then we have a state policy chapter, which is chapter 4, which expressly says that none of the rights under chapter 4, which are all about good governance, can be enforced in courts of law. So chapter 4 was a closed book for all the courts. So what did the courts do? They expanded the right to life to include all the things that you would otherwise have for good governance under chapter 4. And therefore, they came to this, that under 21, the right to issue writs, orders and directions, which are very, very wide, were paramount, which I call the Searchlight provisions of the Constitution, Article 32, which is of the Supreme Court, Article 226, and Article 136 is again through the High Courts to the Supreme Court. These are the Searchlight provisions of the Constitution which were used. And people who say that our courts have crossed the Lakshman Rekha That's a favorite phrase. You read it in newspapers, you hear it on television. It's a figure of speech which is derived from one of the many versions of the Ramayana. But just see what the Ramayana really says. Sita asks Rama to fetch a magical golden deer for her. Rama goes in search of one, asking Lakshmana to stand guard around Sita's dwelling house in Panchavati, which people who know more than I do say is near present-day Nasik in Maharashtra. The golden deer is in fact the demon, Maricha, who distracts Rama, and when Rama kills Maricha, the latter cries out for help, but in Rama's voice, which in turn disturbs Sita because Sita thinks that Rama has been killed. So she creates a panic and orders Lakshmana, the keeper, to go to Rama's aid. And what does Rama do? Out of obedience, he draws a perimeter line round her and says, "You must not cross this," and then goes in search of Rama. And while Lakshmana is away in search of Rama, Sita, out of compassion for a visiting guest, but that visiting guest is not really a visitor, he is Ravana, who is disguised as a poor Brahmin, crosses the line, gives him food. That's what Sita does. Following which, she is abducted, and the rest is history. Now, great constitutionalists apply this metaphor to courts. They say you are forbidden by Article 37 of the Constitution to enforce by writs, orders, the large number of directive principles of state policy which are set forth in Part 4 of the Constitution. It is the same Part 4 that mandates and makes it a duty of the state includes the legislature and the executive, to enforce and implement for the good of India's citizens all the do's and don'ts which are set out in a range of articles, Article 36 to 50. For the constitutionalists, the principles of state policy, which cannot and therefore must not be enforced by courts of law, is the Lakshman Rekha. But ever since 1986, in a case where we had defended the Indian Express building case, the Supreme Court for the first time invoked the Free Press Clause, Article 19(1)(a), even in a purely commercial dispute between the Delhi Development Authority, the DDA, and the national newspaper, the Indian Express. Judges since then have frequently crossed the Lakshman Rekha of Article 37 in matters relating to the provisions of Part 4, simply because the state, that is the legislatures and the executive, have failed to implement or have not implemented the directive principles of state policy. In so doing, and this is to the credit of Professor Upendra Bakshi, he has eloquently told us that, and this is his phrase, the judges sitting in the Supreme Court have converted primary human needs, which are set forth in Part 4, not attended to by those whose duty it is to attend to them, into human rights. Converted human needs into human rights and making them enforceable and enforced under Article 21 of the Constitution. This is a great innovation which the courts have done. And so far, as the Ramayana itself depicts, the boundary line, the Lakshman Rekha, can be crossed only when necessary, but always and only for a good cause. And that's the answer to those who say that the Lakshman Rekha cannot be crossed. Now, our constitution did work well, but only for the first 19 years after 1950. Mark that, up to 69. It ceased to work well the moment politics in our country became immoral and unprincipled. We have not been able to work the parliamentary system, unfortunately. By we, I mean all of us. In fact, we cannot work any system unless we inject some morality into politics. And therefore I was very happy this morning. One value. In social and economic life, we will, because of our social and economic structure, continue to deny the principle of one man, one value. So one man, one vote, but not one man, one value. How long, he asked, this is his quotation, how long shall we continue to deny equality in our social and economic life? And ladies and gentlemen, this question has remained unanswered all these 68 years. A good friend of ours, Professor Glanville Austin, he was a scholar, not a lawyer, not even an Indian, but having the interests of India at heart. He has written one of the finest books on our Constitution. It is titled Working a Democratic Constitution. It's a thick book, published in 2000, Oxford publication. It's not a law book. It's a sociological treatise, replete with anecdotes and instances about how our Constitution worked, how it did not work, and what can make it to work. In this book, Red Austin, he was known as Red. His name is Glanville Austin, Professor. He's known by friends as Red. He died 4 years ago. He saw in our document of governance, our Constitution, 3 strands. 1, protecting and enhancing national unity and integrity. Very, very important. 2, establishing institutions of democracy. And 3, fostering social reform. Taken together, he writes, they form a seamless web. But he adds that lurking in the distance, there is an omnipresent 4th strand, culture. And you will appreciate from the recent Supreme Court judgment what he meant. It has reference to certain traits and ingrained experiences, attitudes of India's citizens, which makes India's soil not very fertile for democracy. It is these